And I've got a fifth too, Assistant District Attorney Noha Elnakib. They will be my prosecution team, and they are standing behind me here right this afternoon. I want to thank them for all the work that they've done so far. I want to thank them for, and my entire office, for moving this case rather swiftly and getting everything done in a proper fashion so that we can be here right now to announce an indictment in this matter. Before I talk about the indictment, let me give you a brief procedural history of what has gone on so far and what has led us to where we're at today. As you know, the defendant was arrested within hours after the alleged incident back on May 14th. He was arrested on one count of murder in the first degree. The reason why murder in the first degree was chosen as the arresting charge was because the probable cause that we had at that time, right then and there, linked to the murder in the first degree right away. Obviously, there were other charges that potentially could have been charged and arrested at that time. But as I said before, all we needed was one charge to hold him and arrest him and to get him off the street and to get him in custody. And so we just happened to choose the charge that had the probable cause staring us right in the face. And that was a murder in the first degree charge. So that was the charge that was initially filed and arrested. As you know, there was a felony hearing date that was scheduled for the following Thursday. That felony hearing date did not go because we took action in the grand jury before that felony hearing date. And once you take any action in a grand jury, that immediately divests the case from city court, which it was arraigned in, and now city court no longer has jurisdiction over the matter at all because we took action in that grand jury. Now, the action that we took in the grand jury was just, again, one charge. It was not complete at that time. It did not have to be complete at that time. We completed the investigation at later dates. And once the grand jury came to conclusion and the investigation was done, the full indictment was reported out yesterday, and the defendant was arraigned this afternoon. He was arraigned on 25 counts of a violation of New York State penal law. The highest charge is domestic act of terrorism motivated by hate in the first degree. This is a relatively new charge in New York State. It's only been on the books since November 1st of 2020. It is the first time in the history of New York State that this domestic terrorism charge motivated by hate in the first degree has been filed. That charge only has one sentence if, in fact, the defendant is found guilty of that charge, and that is life without parole. There is no minimum, there is no maximum. That is the only punishment on that charge. In addition to that charge, he has been charged with 10 counts of murder in the first degree. Now, I could have only charged one count of murder in the first degree if I wanted. That could have satisfied all 10 victims and just had one count. But I chose not to do that. I chose to charge 10 individual counts of murder in the first degree. Again, the legal theory behind murder in the first degree is that 2 or more people died. Obviously, we had 2 or more allegedly in this case right here. And so, like I said, I could have just charged one count and satisfied all 10 in the murder of first degree charge, but I chose not to. I chose to charge 10 separate accounts to list by name the 10 victims, because they deserve to be listed by name. And he needs to be held accountable for all 10. That is why I chose to file 10 separate counts of murder in the first degree. He was then charged with 10 counts of murder in the second degree with a hate crime attached to it. As I've said before, a hate crime in New York State is not an actual separate charge. The way it works in New York State is that you have a foundational charge, whether it's assault, murder, whatever it may be. You have a foundational charge, and then you enhance it with the hate crime. So that is what has been done. I charged also 10 counts of murder in the second degree with a hate crime on all 10 counts for all 10 individuals. And by adding on the hate crime charge, that also elevates it to the same level as murder in the first degree. So at the end of the day, the murder in the first degree and the murder in the second degree are all the same level. You may ask, what was the need of doing that? Why couldn't you just charge the 10 counts of murder in the first degree and leave it alone? Again, I could have done that, but I felt it was important to the community, to the victims, to charge everything that allegedly occurred on this date. And that is why I chose to charge murder in the second degree motivated by hate as well. I then charged 3 counts, and he was indicted on 3 counts of attempted murder. We have 3 individuals who survived. For those 3 individuals who survived, the attempted murder charge has been filed, along with the hate crime on top of that. I will note that 2 of the 3 victims who survived were white. They were not African American. I can still charge a hate crime on the attempted murder for 2 white people as well, because of his alleged intent. And so I did. And then the final charge is a weapons charge, criminal possession of a weapon in the second degree. The weapons charge is due to the modification of the weapon. The weapon itself was purchased legally, but it's the alleged modification of the weapon that resulted in that charge right there. So 25 counts, maximum punishment, life in prison without parole, and I have now given you my reasoning for all of these charges on the indictment. I will now go into what happens next. I'll talk about what happens next on 2 fronts. I'll talk about what happens next from a procedural front, and also what happens next on a communication front. First, procedurally, the next court appearance is July 7th at 2 p.m. for a further proceeding. That is, as you can know now, over a month out. That gives us time now to turn all the discovery over to the defense team. I will note that I've already given the defense team a copy of the indictment. They asked for it yesterday, and I most graciously obliged that and gave them a copy of the indictment. And then now we have a month to turn over all the discovery and to give them all the evidence. From a communication front, this is the last time you will hear from me or from anyone in my office. That is not unusual. After a arraignment on the indictment, I never speak until the matter is concluded. That has been my MO for the past 5.5 years. I'm not going to change that now. But on top of not changing my normal MO, I have formally agreed to that as well. As everyone knows, the defense team filed a week or so ago an order, a gag order against me, so that I could be precluded from talking about this case. The defense attorneys and I and the judge came to a resolution, an agreement, that I be able to talk today about the charges, about the indictment, about the elements of the crime, about the procedural nature of what's happening next. But I agreed not to talk about the evidence or talk about any facts of the case at all. So I will honor my agreement. I told the judge that I wouldn't do that anyway in open court. I gave the judge my word. I gave the defense attorneys my word as well, and my word is golden. I really don't need an order, quite frankly. If I say I'm going to do something and I give you my word, I'm going to do it. So I will not be talking about any facts of the case here right now. I will not be talking about any evidence at all. I will not even get cute. I could probably get cute and have the police department or FBI talk about evidence or talk about the facts of the case and have me sit over here and be quiet. I could probably get around the gag order doing that. But you know what? I'm not going to do that. I'm not going to get cute at all. So they will not be talking about the facts or evidence either. I will note that, and I said it in open court, I'm obviously a little miffed by the gag order, to tell you the truth. I clearly did nothing wrong before today in speaking about this case. I was accused of making two statements. One had to do with the mental health process that occurred here, where I made a comment that once the defense team pulled their request to have a forensic, that it was a moot point. I clearly was talking about it being a moot point for the felony hearing, and only for the felony hearing. I clearly established that. I clearly said that. I was not in any manner saying it was a moot point going forward indefinitely. If I implied that, I am sorry. But I know I did not imply that. I know I did not say that. And on top of that, I explained it was only for the felony hearing. So I'm not sure how there was any confusion there, but I'm a big man. If there was, I apologize. The second argument that they made was that I talked about some potential misconduct that was uncharged. Again, I did not do that. I mentioned other potential charges that were in the penal law that we were looking at potentially. I use the word potentially like probably 1,000 times. The reason why I did that is because, as you know, I got some criticism for only charging the murder in the first degree. People were questioning me and criticizing me, well, why didn't you charge the hate crime right away? I was even called out by a reporter, who's not here today, at the press conference we had on Saturday night there after the shooting, that why didn't you charge the hate crime right away? So I had to explain, obviously, that the reason why I didn't charge the hate crime right away is because we had to keep doing the investigation more. The murder in the first degree charge was staring me right in the face. Now, one could make the argument that hate crime was staring you in the face as well. I recognize that, but the hate crime is more nuanced. The hate crime is an enhancement to an underlying charge. And so there's more to that. And I want to make sure I have my I's dotted and T's crossed before I added on more charges. So I had to explain that, obviously, because I was getting criticized for not initially charging the hate crime. That was my only motivation in doing that. That was it. It wasn't to say that he did something wrong that he wasn't charged with. It wasn't to say anything improper at all. It was only to explain why I didn't charge the hate crime. Again, now, quite frankly, it's a moot point, because every charge that I talked about that we were looking at, I have now charged. And so, again, that argument is moot. I have clearly said from day one that this defendant is innocent until proven guilty. I repeat that right now. This indictment are just allegations. He has not been found guilty of anything. He is innocent until proven guilty. Everything right here in front of us right now are just accusations and allegations. And I will do my darndest to ensure he gets a fair trial. And anyone who implies that he's not going to get a fair trial, that I somehow have prejudiced him having a fair trial, is ridiculous. I've said it in front of the cameras before, and I've said it again today. How these are just accusations, and he is innocent right now. So I think that that's now been cleared up. Again, after today, I'm not going to talk anyway, so I've given my word, and we move forward. We move forward now with the prosecution. I kind of want to generally give some thank yous here, and then I want to give some specifics. Obviously, all of law enforcement, from the Sheriff's Department to the State Police to the ATF to the U.S. Attorney's Office, have been just extremely helpful in getting us to where we're at today. I can't thank the FBI enough. The special agent in charge, Steve Bologna here from the FBI, him and Director Ray in D.C. have done everything to assist us. We are total partners in this prosecution. The evidence that they've collected and the work that they've done to help me out. And it's that partnership with the FBI that I have, going back years and years, that has fostered that sense of relationship and partnership that we have got, here today. And this should be a model nationwide as to how local law enforcement and federal law enforcement can work together in a state prosecution. And that is what we've done, Steve, and I can't thank you enough, or Director Ray. Director Ray also sent down 16 victim advocates from D.C. to help the victims out in this case. Director Ray and the FBI have basically opened up their pocketbook to this community. To whatever we need, they are there to help us. I was in D.C. last week. I met with the Attorney General, the Deputy Attorney General, the Assistant Attorney General in charge of the Criminal Division, and all three of them basically said to me, whatever you need, you got. And it's that partnership.
And we have been listening to Erie County District Attorney John Flynn discussing the arraignment of the Buffalo mass shooting suspect. He's being charged with first-degree murder, domestic terrorism, and hate crime charges for last month's shooting inside a supermarket.
The DA explained why he filed murder charges for each of the 10 victims. He also said he will not discuss the case any further until after the trial.
And we want to take you now to the White House, where Press Secretary Karine Jean-Pierre is holding the daily press briefing.
Today, she is joined by White House coordinator of the COVID-19 response, Dr. Ashish Jha. Let's watch.
We'll be meeting on June 14th and 15th. They will review the data submitted by Pfizer and Moderna for their vaccines, and we expect an FDA decision shortly after the advisory committee meeting. And we look forward to this process playing out. Now, as you all know, because we've been through this many times, the FDA authorization is not the final step in the process. Before vaccinations can begin, CDC must also issue its recommendations. If the FDA authorizes the vaccines, the CDC will have its advisory committee meetings, and ultimately the CDC director will make her recommendations. And we expect the CDC to make its dates for its advisory committee meetings public very, very soon. So let's talk about what we know at this moment. We know that many, many parents are eager to vaccinate their youngest kids. And it's important to do this right. And that's what this process has been all about. So as I talk through the process today, I want to be very clear that I am not here to prejudge the outcome of the process. But the administration is hard at work planning all sorts of scenarios based on whatever the outcome is from the process that's playing out. We've been working very closely with states, with local health departments, with pediatricians, family physicians, other healthcare providers, and pharmacies to get ready. We started with the playbook we've used for rollout of vaccines for other age groups. At the same time, we're building this program to meet the specific needs of this specific age group. We expect that the vast majority of these kids will be vaccinated by their primary care providers. Now, if and when FDA authorizes a vaccine, we'll move from planning to execution. So let me highlight a few things of what that will look like. Now, the good news is we have plenty of supply of both Pfizer and Moderna vaccines to start our vaccination program. And we are going to make 10 million doses available to states, pharmacies, and community health centers and federal entities to order initially. Starting tomorrow, states can begin to place their orders. We have asked states to distribute the initial tranche of doses to their highest priority sites, including those serving the highest risk children and hardest to reach areas. And we've also asked them to prioritize sites that can handle large volumes, such as children's hospitals. We've encouraged states and providers to find ways to ensure that parents have access to these vaccines for their kids outside of normal work hours, because we want to make this as easy as possible for working parents and their families. Now, FDA authorization will allow us to start shipping doses. These doses are specifically formulated for these young kids. These doses will be shipped to thousands of sites across the country. So let me go back and think through the timeline with all of you. VRBPAC meets on June 14th and 15th. We expect FDA to make its decision soon thereafter. Once FDA has authorized, if they have authorized vaccines, we can begin shipping. We expect some of the shipments to start arriving in their destination over that long weekend. Remember, Monday is an important federal holiday, and many doctors' offices may be closed. And we can't ship vaccines until FDA has authorized these vaccines. And vaccinations can't start until CDC has issued its recommendations. So we expect that vaccinations will begin in earnest as early as Tuesday, June 21st, and really roll on throughout that week. Now, it will take some time to ramp up the program and for vaccines to be more widely available. And as doses arrive in places throughout the country, more sites will have vaccines, more appointments will become available. And our expectation is that within weeks, every parent who wants their child to get vaccinated will be able to get an appointment. We will, of course, do our part. We're going to continue monitoring. We're going to ship doses out as fast as possible. We're going to make sure that supply is always meeting demand. And we're going to do everything we can to make it easy for providers and parents alike to get their kids vaccinated. So let me just close with a few words about the bigger picture about the moment we're in. It's been a long 2 years. This is the last group of Americans who have not yet been eligible to get vaccinated. But as we think about getting ready to vaccinate our youngest kids, it's worth noting how much progress we've made. 2/3 of all Americans are now fully vaccinated. Close to 1/3 of all Americans are boosted. And highly effective treatments are widely available. As a result, when we look across the country, we see cases rising, nearly 100,000 cases a day, and yet we're still seeing death numbers that are substantially about 90% lower than where they were when the president first took office. Now, we know that COVID isn't over. We still have work to do, but we have made tremendous progress. And what we know is that we've got to keep vaccinating, keep reaching people who have not gotten vaccinated, keep making treatments widely available. Because what we believe is that with science, with hard work, and with resources, we can continue to protect the American people from our oldest to our youngest. So thank you, and I'm looking forward to questions.
All right. Okay. Another question.
Well, what's your expectation on when most kids will be vaccinated? Is it a matter of months? What's your estimate?
So we don't have an estimate of timelines of when most kids will be vaccinated. What we know is that obviously there are a lot of parents who are eager to get their kids vaccinated right away, and they will get vaccinated right away. Within weeks, as I laid out. There are other parents who are waiting to see how things go. And I think what we have seen in the past is that they will come on board as they see their friends and family getting their kids vaccinated. So I think this is a process that's going to take some time, but we want to make sure that we always have adequate supply and access for parents when they want their kids vaccinated.
So I think you are well aware about how much frustration and anger there's been from parents of young children. The fact we were talking about second boosters for much of the population before even this first one was available. I'm a parent of a 4-year-old who got COVID while we sat around waiting for this. And I think one point in all of that really is frustrating, raises a lot of questions for parents, is why the FDA didn't move to hold hearing right away after Moderna applied, why it waited for Pfizer and Moderna. Can you just explain the thinking behind that delay?
So, first of all, I have a 10-year-old, so he's been able to get vaccinated, but I have a lot of friends who have kids under 5. So let me just say I feel the frustration. I certainly hear the frustration. Two things. First of all, the FDA makes its decisions on timelines really based on its ability to review the data, to do a careful analysis, and that's what they've been doing. I think they've done that throughout the entire pandemic. If you look at from the early days of the early adult vaccines through this one, they have moved expeditiously, and they have made the determinations of when they can be ready to evaluate and when they can make a decision. The specifics of it, you're going to have to, I think, ultimately talk to the FDA, but I feel like they have moved very quickly to try to consume and analyze a very large tranche of data from Moderna. And look, at the end of the day, we all want to move fast, but we want to get it right. And that has got to be priority number one, and that's what I think the FDA has been focused on.
On Paxlovid, do you have any information you can share with us on how much Paxlovid has been used so far and how much is left, and whether Congress or whether the U.S. is committed to completing its purchase of the 20 million courses?
I don't have the numbers off the top of my head. What I will tell you is we're getting out about 30,000 prescriptions a day right now. And that's at the end of last week. I don't have this week's data yet. So about 30,000 doses a day. We obviously want to continue to expand access to Paxlovid for any high-risk person who gets infected. We want to make sure they have access to it if they're clinically eligible. The president made a commitment to get 20 million doses, and we remain committed to making that happen.
Thank you. I wanted to ask about your COVID testing program, specifically the one that was launched to order COVID tests at home. Can you talk about what the demand has looked like lately now that we're seeing up and down with cases and different than what we saw around Christmas? And what you're doing to preserve supply. I know that these tests eventually expire. What you're doing to preserve supply should there be a big demand again?
Great question. So we launched that about 3 weeks ago. I can't remember the exact time, the third round of making tests available. We actually saw quite a robust demand for that. I think we've had maybe 17, 18 million households order just in the last couple of weeks. So that on round 3, that's a lot. and it's great, and it means that people are still using these tests. If you've followed me for the last 2 years, you know I'm a huge believer in making widespread testing widely available. I think getting people tests at home is a really important part of that. We feel that when you have cases rising, Americans want tests. We want to make those tests available. We also obviously want to make sure that as we have future, if and or when we have future surges of infections, we will have other tests available for Americans.
Can you also talk about the president was very big at the beginning of that program on equity, and that these tests were going to be distributed to populations that were underserved in addition to populations that might be more well-connected?
So we've thought a lot about equity in this case, in other areas too, but certainly on tests. Yeah, and so the way we've done this is, I mean, obviously website, but you can make phone calls, which for some people is easier. We've distributed tests to food banks. We've distributed tests to federally qualified health centers. We have a whole series of efforts that we have had to make sure that the testing is getting out through a variety of different channels so that people who may not